come. I don't want to get into a technical fight about the subpoena. But quite honestly, Judge, legally, they need to give appropriate notice. I can pull the statute, I had it ready for Mr. Strani, of days' notice. So he's not obligated to accept service if that service is for any time other than sometime next week, with all due respect. And he has been on their list. I can pull the very first time, if the court wants, that they listed Detective Ruano, but I could assure you it was months, if not over a year ago.
Okay, I'm going to ask the state to do the court a favor, which is to reach out for him and find out what his availability is this week, because
no problem.
I don't want this case going into next week.
Yes.
I don't think the jurors want this case to go over next week. Right now, my number one priority is the jurors.
Correct.
And I know that they all have expressed concern about this case going into next week. So if he would kindly walk through that front door, then that would be appreciated. Otherwise, we're putting ourselves in a position where the case could be continued.
Okay, we'll reach out to him, Judge.
Thank you.
Yeah,
No problem.
You may. Thank you.
Judge, I have another issue.
Okay. Anything else from the defense?
Yes, Judge. The program that Mr. Schumacher uses is QuickTime,
Okay.
which is actually, I think it's one of the options that the computer, which is, I don't want to say antiquated, but it's an old computer. But every Mac comes with QuickTime Player.
And will Mr. Schumacher have his computer with the program that he plans on using in court available during the deposition to show us exactly what program he's referring to?
When he can do it on his laptop. He has a computer. Hold on, I can show you.
So why don't you ask Mr. Padilla to ask those questions and ask that he have those.
I just want to know if I need to provide him with a laptop, if I need anything to be brought. I just want to be completely prepared for the deposition.
Judge, I apologize. I'm sorry. It's my understanding that Mr. Schumacher has his laptop at the hospital. I don't know. Does the prosecution wish to depose him today at the hospital, or I don't know what they want to do?
Well, first of all, how many witnesses do you have ready to go today? Because I want to get through the defense's case.
With the exception of Mr. Schumacher, we have Detective Lopez, and if we can get in Detective Ruano, Detective Ruano.
Then after that, other than the possibility of Mr. Medina and Mr. Schumacher.
And Mr. No, Judge. No, he's not. Okay, good. So just those two, Judge.
Scott?
I know, right? I can't see. I didn't realize it was that much. When I put it up this morning, because we get paid Wednesday since we're not here Friday. So I pulled out my phone. I was like, oh.
Okay, so state defense, Mr. Medina, on back. Present state.
Yes, Judge, I spoke with Detective Rolando.
Mr. Zagman? Mr. Zagman?
Yes, Judge.
Please.
Judge, I was able to speak with Detective Rolando of Miami-Dade Police Department. The problem is he's not refusing to accept service. What he tells me is there's a process server at his office trying to personally serve him, and that's not how it's done. The defense is supposed to serve them through court liaison, so they're not serving the police properly. Nonetheless, Detective Rolando states that he's more than happy to come today, and we will produce him. The problem is, I don't think he's going to be able to do what the defense wants him to do, which is authenticate the video that I sent to them in a minute discovery. The reason I don't think he's going to be able to do that is because he cannot authenticate something he did not create. He gave me an original disc. I made a copy of that disc, or I emailed, I should say, the contents of that disc to defense counsel as a minute discovery. But Detective Rolando can only authenticate the disc he gave me because it has his name on it, his case number, etc. If the defense produces a disc that they've burned that information onto it, he's not going to take the stand and authenticate something he didn't create because he can't say that that disc is in fact what he created, that those files have not been altered. So while I'm happy to produce him this afternoon, I don't think the defense is going to get out on what they want, which is to authenticate that evidence, because I have the only disc in the
Well, all I need to do is I need to know if Detective Rolando will appear in the court. The rest is
He will be here,
defense.
He will be here, Judge. What time do you want him
I
here?
told him after lunch.
That's up to the. That's up to
He's
the-
not dressed for court, but he has to get dressed appropriately for court. I told him after lunch that would be okay. He said that would give him enough time to go home, get dressed, and then
As long as he's wearing pants, that's
Right, and just for the record, Judge, the prosecution did amend discovery with 156 stills, which were created by Detective Rolando.
Okay, well, listen, how you present your case is how you present your case. Detective Rolando seems that he is willing to appear today. What time would you like him present?
She could be here at 11:30?
Judge, we can try. I mean, we'll call him back. But
Okay,
I mean,
see what you can do closest to that. Okay.
closest to lunchtime, that's fine.
Okay. Okay. Anything else from the state?
Yes, Judge. Judge, are we, I don't know, I'm not sure exactly, forgive me, where we've left off in terms of defense exhibits A5 through 10, and if they're trying to use them or not, or...
They seem to have abandoned that.
That's fine, I'm just letting you know I haven't gotten them. Judge, in addition, I'm going to keep raising this. I raised it Friday afternoon, and I'm going to raise it again. Judge, on Thursday, we received the raw data from NMS Labs, and we were not able to open it. The court knows that we needed that information so we could go through
Do I
it.
have a defense attorney paying attention to the state?
Yeah, Judge, Mr. Yaber is.
Go ahead.
So we could go through it with our experts and see if there was anything there since we had not been provided sooner. We immediately communicated with Mr. Padilla Thursday night that we could not open it. I then brought it up again on Friday. I'm just keeping it on the record, Judge, very clear that to this date we have not been given any access to how to access that data. So I don't want there to be any delay later that's attributable to us, so I'm just putting it on the court's radar. That's all. I'm not inquiring as to how anybody's proceeding. I'm merely just saying that we have still not gotten any communication back as to how to access that data. That's all.
Would you like to place anything on the record?
No, Judge.
Okay. Anything else from the state?
No?
Okay. Anything else from the defense?
Judge, we've had some issues with a jointly listed state and defense witness. She is refusing to get in contact with us. It's a witness that I don't necessarily believe that we need at this point. I'm not sure if I have the same feelings as my client. It is Brittany Odell. She's not, we don't have communication with her. We attempted to contact her to bring her in, and she is, in essence, not responding to our requests, Judge. I know that there was a situation where she had indicated that she would come if we would supply travel. And I'll tell you this, Judge, I don't have firsthand knowledge. This is my recollection. So let me do this. Let me withdraw this. Let me confirm exactly what's going on before.
Judge, I'll cut to the chase, though. We don't have contact with her either. So if this is the type of situation where defense would like us to help get her in, we can't because
I know, and she's a civilian, and I know that they can only do what we're doing.
Okay, well, if you're going to make this motion, you have to show me evidence of what you've done to try to serve her appropriately for court today.
Yes, Judge.
Okay. Okay, otherwise, is the defense ready to go this morning?
Yes, Judge.
Okay, is the state ready? Ready. The jurors are outside, so let us begin.
Oh, Judge, there is one last issue. I wanted clarification on the court's ruling with regards to the decedent's mother. I know that we've called her in the defense case in chief, and we proffered one question. The court sustained the objection. I wanted clarification on that issue, and this is something that I try to bring to the court's attention. Sidebar, I think that it was at the end of the week we were all just kind of running on fumes. One of the things that the court has said from the inception is if we were to present a battered spouse syndrome defense, we needed to lay a foundation. One of those issues was, one of the ways that we were going to do that was through Ms. Knox, by asking her if she's ever reprimanded her daughter. It's not a hearsay statement. It is an action that we're asking her about.
Why is it relevant if she's ever reprimanded her daughter?
For punching Derek in the face. I had to finish the question. If she's ever reprimanded her daughter for striking my client in the face, the answer is going to be yes. It's what she says in her deposition testimony. Okay? We believe that starts to lay the foundation for a battered spousal syndrome application of an instruction.
Do you have her deposition?
I do, Judge.
My recollection is that Ms. Knox did not witness Jennifer Alfonso touch or strike Derek Medina. That to the extent that she said anything in her depo, it was that her daughter told her of the incident where she touched or struck Derek Medina. But that, of course, would be inadmissible hearsay. So if the jury can't hear through hearsay, if the hearsay statement by Jennifer to her mother, I hit Derek, is inadmissible, then why would the subsequent reprimand for hitting Derek be admissible? I mean, it's getting the hearsay in indirectly, essentially. So I think the issue is what is the hearsay exception, if any, to Miss Knox testifying that my daughter told me once that she hit the defendant.
Okay, I'll review this during the first witness, so we'll have a sidebar about it.
Yes, Judge. Thank you.
Can you point to me some pages?
Pages 39. 39, it starts page line 5. And I'm missing my page 40, Judge. I know the page is somewhere, but it starts on page 39. And it's on page 39 and 40, Judge.
Why you want to hurt me?
Please rise. You may be seated.
For the record, the State Defense, Mr. Medina, all of our jurors are accounted for. I know it was too short, but I hope you all had a nice weekend. Ladies and gentlemen, have you followed my instructions and orders as always? Yes. Good to see you all. Defense, would you like to call your next witness, please?
Yes, Judge, respectfully. At this point, the defense calls Detective Jose Lopez.
Detective, if you come forward and sworn, please.
Do you swear affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth?
I do.
You may have a seat at the witness stand.
Good morning, sir. Please make sure all of your answers are out loud, verbal, so that all of our jurors can hear you. Thank you.
Yes, sir.
You may begin when he is comfortable.
Thank you. Good morning. Good morning, Detective. You comfortable?
I'm comfortable.
All right, great. Please introduce yourselves to the ladies and gentlemen of the jury.
I'm Officer Jose Lopez with the City of South Miami Police Department.
And how long have you been an officer of South Miami?
I have been with them now almost 11 years.
And were you an officer someplace else before joining South Miami?
Yes, I was.
Where was that?
Sweetwater Police Department.
And how long did you hold that capacity over?
9 years.
So in total, how long have you been a law enforcement officer?
Going on 20 years.
What were your duties on August 8th, 2013, if you recall?
I was assigned to the Criminal Investigations Division.
At some point in the morning, were you drawn to the lobby area of the South Miami Police Department?
Yes, I was.
Tell us what happened.
We received a phone call from our dispatcher telling us that there was a gentleman that was turning himself in for killing somebody.
And as a result of getting that call, what did you do?
Myself and Detective King went downstairs. We had been working another case of a prior homicide, and we thought that it was related to that case.
But it wasn't, right?
It was not.
Okay.
It was not. We went downstairs. When you go downstairs in our station, the door has a little window. I looked through the window of the door and I saw that. I didn't think it was going to be related to that particular case. So I walked around to the dispatch area and asked the dispatcher what was it exactly what was going on. And she said that this gentleman had come in and said that he had just killed his wife.
Did you then subsequently go into the lobby area?
Yes. I asked her for the address to make sure that it was in our jurisdiction. And then I walked outside to the lobby area with Detective King.
Was there anybody else in the lobby area with you when you were out there with Detective King?
It was the defendant, Mr. Medina, I believe his father, Officer Venturi, and Officer Everett.
And correct me if I'm wrong, well, describe how big the lobby is of the South Miami Police Department. That area, well, let me rephrase it. Describe the area where my client, his father, and all these officers were. How big of an area was it?
Probably a little bit bigger than the jury box.
Okay. So if somebody is at the far right corner and they say something, would somebody in the far left corner be able to hear it?
Sustained.
Do you know if somebody in the far right corner speaks out loud, if someone in the left-hand corner can hear it?
If they're not mumbling.
Overruled.
Go ahead, you can answer.
If they're not mumbling and they're clear, yes.
Did you have an opportunity to hear any statements made by my client in your presence?
Yes.
Can you tell the members of the jury what that statement was?
When I walked in, he was already speaking to the officers, Officer Venturi and Officer Everett. And he stated that he had gotten into an argument with his wife. The argument had escalated into her hitting him pushing her back, hitting her back, and then she grabbed the knife, he grabbed his gun and shot her.
Did he tell you whether or not, do you recall him making any statements as to whether or not he had a choice in the matter?
No.
Is there something that I could show you that would potentially refresh your recollection?
Sure.
I'm going to show you your deposition transcript, page 9. May I approach?
Yes, you may.
Go ahead and take a look at page 9 of your deposition transcript, and then when your recollection is refreshed, let me know.
You want me to read this?
Well, I mean, once you've read it.
Oh,
I mean, you gave a deposition in this case, correct?
yes. Yeah.
May I approach? Have you
Yes.
read that area?
I read the highlighted area, yes.
May I approach?
Yes.
You have a standing permission to approach.
I'm sorry?
You have standing.
Thank you, Judge. Now, I'll ask you again. Do you recall if he told you if you had any choice in shooting?
According to my statement, he said that he had no choice but to shoot.
Nothing further.
Cross-examination?
Yes, Judge.
Morning, Detective.
Good morning.
How are you?
Good, and yourself?
So, you're not a uniform officer, right?
I'm in uniform now, yes, I am.
Okay. At the time, you were a detective along
I
with
was-
Detective King.
Yes.
All right. And you were on duty that morning at the police station, correct?
Yes.
All right. And you got the word that there was something going on in the lobby.
Yes.
So you go downstairs and you see first you talk to Christine Massey, correct?
Correct.
All right. Miss Massey is the first person you see when you walk into the lobby, right?
When I saw the defendant, I looked through the little window. When I went into the dispatch area, that's the first person I saw.
Okay. I should have said the first person you spoke to.
Yes.
Was Miss Massey. All right. And you say that Miss Massey told you generally, basically what the defendant had said.
Correct.
Okay. And did Miss Massey tell you that the defendant came in claiming he had shot his wife, correct?
Yes.
And that she had pulled a knife on him.
I don't recall if that's what she told me,
Okay. But he had shot his wife.
but that he had shot herself.
And then after getting that preliminary information, you realize, okay, this is not the case I thought it might be, right?
Correct.
You went around and you saw Mr. Medina directly.
Correct.
And at that point, he was already talking to Everett and I think it was Venturi, right?
Correct.
They got there before you.
Yes.
Okay. You and Miss King, Detective King, arrived at the same time, correct?
Correct.
All right. You walked into that door together, essentially, right?
Correct.
All right. And this whole thing was caught on video, right?
Yes.
Right. Okay. And so you came in the middle of a conversation between the defendant and officers Venturi and Officer Everett.
Pretty much, yes.
You didn't catch anything Mr. Medina might have said prior to Officers Venturi and Everett before you came through the door, right?
No.
Because you weren't listening, you didn't hear, you weren't paying attention.
I wouldn't be able to hear it because of the glass plate and the door.
Okay, so would it be fair to say that the entire story, the entire context of whatever Mr. Medina was communicating as far as the shooting of his wife, you heard part of it, not all of it?
Correct.
Okay. And in terms of the details of the sequence of events that led up to the shooting of his wife, you did not take a post-Miranda statement of the defendant to get a very, very detailed statement, correct?
No, I didn't.
Isn't it true that once you heard generally, okay, we've got a possible shooting in the city, and we've got a possibly deceased or shot victim, you and Detective King actually left pretty quickly?
Correct.
Right.
I told him to secure Mr. Medina and his father, and we left.
Right. And so you really didn't stick around for very long while Mr. Medina was talking to Officers Venturi and Everett.
Correct.
You went to take care of the actual scene of the shooting, right?
Correct.
And you did, in fact, respond to the scene of the shooting.
Correct.
And you found the victim there and the little girl in the house, correct?
Yes, sir.
Right. Okay. And after that, you had no further dealings with Mr. Medina, correct?
Correct.
So you did not, for example, go back to Miami-Dade headquarters to participate in his post-Miranda statement, correct?
I did not.
You weren't there with Detective
Objection, Judge, beyond the scope.
Overruled.
You weren't there with the detectives who might have gotten additional further exact details into what happened between him and his wife that morning, correct?
I was not.
Thank you. No further questions, Your Honor.
Redirect.
Just so I'm clear on this, Detective. The prosecution said that you didn't hear the conversation of Officer Everett and Officer Venturi, but tell me again what you heard when you walked in, what my client told you in front of these officers.
That he had gotten into an argument with his wife.
Mm-hmm.
That it had escalated.
Right.
That they had exchanged blows or punching each other, and she came at him with a knife, and that he shot her.
He had no choice to
That he
shoot.
had no choice to shoot her.
Okay. When he made this statement, did he appear to be under, he made it freely and voluntarily, correct?
Yeah, he was just giving a verbal statement.
Okay. And this happened around what time in the morning? Do you recall?
If I recall correctly, it was somewhere around 11 o'clock in the morning because we were getting ready to go to lunch.
And as a result of this, as being part of this investigation, did you at some point later on find out what time the actual shooting took place?
Throughout the investigation, yeah, had occurred much earlier.
Okay. The shooting had occurred much earlier than when you saw him in the lobby?
Than what we saw in the lobby.
Is much earlier an hour? What do you consider much earlier?
Over an hour.
So it's your testimony.
It was not just occurred. It had not.
I'm sorry?
It had not just occurred.
Did you have any subsequent discussions with any other law enforcement officers as to the time of the actual shooting?
Only if you know firsthand, sir. Do not guess or assume. If you do not know, you may say, I do not know.
I don't recall.
Okay, that's fair. Officer Ventrilli, was he in the lobby when the statement was being made? Ventrilli, am I pronouncing it? Venturi. Do you
Yes.
recall?
Everett, Officer Everett and Officer Venturi that I recall were both in the lobby when I got there.
Okay. And you agreed with me that the lobby area is about the size of the jury box?
Pretty much, maybe a little bigger.
And do you recall if my client was sitting in the middle? Do you recall where he was sitting?
Yeah, basically in the middle of the lobby.
And do you recall how close Officer Ventrilli was to him? Was he right next to him?
If I recall correctly, Officer Everett was to his left, and Officer Venturi was standing by the door.
Okay. And you were in between those two? Is that a
Yes.
Okay.
You refer back to the video.
And Detective King was there as well?
Yes.
And they were all four in that area where my client said what you testified to today, correct?
Correct.
That, now you indicated that you said that they were exchanging blows, correct?
Yeah, I don't remember the exact words right now, I don't recall exactly, but that they were fighting, that they were having,
Well, I have your exact words. If I showed you your
Okay.
deposition transcript, would that refresh your recollection?
absolutely.
May I approach, Judge?
You may.
Thank you. I'm referring you to page 9 of your deposition transcript again. When your recollections refresh regarding what he told you with regards to the fight, let me know. Look up.
Hey. Yes.
Okay, man. Okay. So now that you've had the opportunity to look at your deposition testimony,
Yes.
tell the jury if your recollection's been refreshed and how it's been refreshed.
That she was punching him and that he had blocked me, he had no choice but to shoot.
Okay. So this is a little bit different than when you testified that they were exchanging blows. Your testimony, now that it's been refreshed, is that she was punching him, he was blocking those punches, correct?
Correct.
Nothing further, Judge.
Thank you. Detective, you are excused. Defense, would you like to call your next witness?
Can we come sidebar, Judge?
One moment. Gentlemen, at this time, there is a legal issue that needs to be addressed outside of your presence. I do beg for your patience and understanding, but this may take some time. It is now 10:40 in the morning. Go about your business as you wish. I will ask you to be present at 11:10 outside. Thank you. At Jose's Secret Hiding Space. Please remember my rules and orders as always.
Please rise.
Okay, let's be seated, please, with the State Defense, Mr. Medina, still present. Okay, now let me ask the defense, have you learned anything new about Mr. Schumacher's...
Judge, I'm going to go make a call right now.
Okay,
Give me
so we'll be in a 5-minute recess.
my liaison with Mr. Schumacher.
Let me ask, Mr. Yabo, do you all have your copies of the jury instructions? Because we're going to spend this time working on the jury instruction. Do you have a printed out copy ready to go? State, do you need a copy of the jury instructions? Because I'm going to try to spend this time productively and work on our jury instructions. Do you have a copy, or do you need a printed out copy? I'm happy to do it.
I don't have a hard copy. I need
She's
a hard
about to make me a copy.
I need a hard copy, Judge.
Okay.
Judge, sorry.
Defense, do you need a hard copy, or you have?
No, I have.
Okay.
That's it, right.
Yeah, so ask for 3 copies.
3 copies.
Just tell them I'm mailing it to her right now.
Okay.
Just before we start on the jury instructions, can I take a quick restroom break?
So what this is on this record.
Good morning, dear. The judge says you need 3 copies. Don't make me laugh. We on a break anyway, so. So why? I know that's what she said. She said, "Y'all know I'm supposed to be on vacation this week." I'm like, "So why are you here?" No, that's it could continue to next week. So nobody cares. I know it. You got my baby with you? Oh man, I guess I have to catch on lunch again. Okay, bye. Nikki crazy. She fussing at me, talking about she's supposed to be on vacation this week. I said, "Why you fussing at me?"
You can borrow me.
Judge, I wanted to bring...
For the record, with the State Defense, Mr. Medina still present, yes.
Okay, I've spoken to Mr. Schumacher. We believe he'll be released after 1:30 tomorrow. He's available for depot now, anytime today. So this is the way I look at it, Judge. After Detective Ruano, we really don't... We're in a position, because of exceptional circumstances of Mr. Schumacher's medical condition that we cannot move forward. We're asking the court for a 24-hour continuance or 26 hours, so the prosecution can A, go depose him, and B, we can present him as a witness. I think under 3.191, subsection 18, there's a provision for exceptional circumstances. And I believe the fact that our witness, who, as I've proffered to you what his testimony is going to be, it's instrumental to our defense, to our self-defense allegation in this case, that he will not be able to testify because of a medical emergency. Now, mind you, Judge, Mr. Schumacher is from California. So he came here strictly for this case. He's been in the emergency room and he's been admitted in Mount Sinai from a post. I believe he got an infection as a result of his current medical condition, which I'm not at liberty to say on the record. I can say it's signed by a judge, but he subsequently got a staph infection and now he has a blood clot in his neck. They're not releasing him. They will not allow him to be released until the thrombin, which is the blood thinner, they feel comfortable enough to release him. They've indicated that release date will be tomorrow. Is it 3.91?
I know it's your counsel.
No, it's fine, Judge, because this is...
It's 3.190, Judge. I'm sorry, Ms. Klein. And it's subsection 18, exceptional circumstances. Is it subsection 18?
There is no subsection 18.
I'm sorry. It's 3.190, is it J?
Why don't you go look?
Right, we're looking up right now, Judge.
Judge, there is a motion, there is a section on exceptional circumstances, and that would be in Rule 3.191 under speedy trial, and that would be subsection L. And that is when, that's in a speedy trial situation, which we're not in, but nonetheless, it's...
Okay, well, first let me ask the state. I've granted you the ability to take a deposition. How would you like to effectuate that?
So, Judge, which sort of brings me to a scheduling issue. I also just want to remind the court, Judge, that just because we're taking the depo, that doesn't mean that it ends there and that like he's ready to testify, because as I let the court know, I don't know what's going to come out, if there's some shadow science that he's talking about that we might need to file further motions on, etc. So I just want to sort of remind the court that I had obviously disclosed that previously. Judge, here's the situation. I was hoping, the state was hoping, to really have this case to the jury by tomorrow. I think that everyone in this case, the court, the state, the defense, and the jurors have worked too hard for them to have the onus of having them put this on them on Wednesday when Thursday everything is closed, it is Thanksgiving, people have Thanksgiving preparations on their mind, and they're sitting here having to rush to decide a verdict so that they can go out and finish their shopping to get home to their families. I just don't think it's fair to the case for all parties involved. And so, you know, I don't want to
exclude a witness based upon.
I'm not asking for exclusion, Judge. I'm not asking for exclusion yet. So, if he can't testify till 1:30 tomorrow, right, assuming that the state has no motions. Let's say we go take his deposition this afternoon, okay, at the hospital. They can provide a court reporter. I don't know if a court reporter will necessarily be coming over there, but I'm assuming they can provide for a court reporter. And we can go over there this afternoon, let's say, to take their deposition in the hospital, provided that we got something from a doctor that said that he was not in a contagious position, because what was first represented to the court about his condition, I don't want to discuss it, was that it was a form of an infectious disease, and so I just want to, for everybody's safety. And assuming the state had no further motions, if he testifies tomorrow afternoon, would we then be going into, I guess that's my question, Judge, would we then go into closings first thing Tuesday night, maybe asking the jurors, we provide them dinner if they want to work late Tuesday in light of the fact that it's Wednesday? I'm trying to gauge that, meaning if we're not going to do that and we're in a situation where the court's going to say, you know what, I'm giving the jurors off Wednesday, we'll just do closings and everything first thing Monday, then I'll do
Monday because the court has travel plans that cannot be changed for the Thanksgiving holiday.
So then if it's going to be Tuesday, or if, do you understand why I'm asking the question, Judge? I'm not trying to...
I do understand the situation. I think this is one where we're just going to have to be a little bit flexible and figure out what our status is. I mean, you know, defense, I'm going to put this out there because I spent a good portion of the weekend doing a search federally, state, all states, and I could not find a single case. Doesn't mean it's out. Doesn't mean it's not out there, because obviously it wasn't as exhaustive as I would like. That has ever permitted shadow testimony. So I would, at this point, I would even like a proffer of how. So he puts in the DVD with QuickTime. What does it do? What does it show? What will he opine?
Well,
Can you give us a proffer in advance?
Absolutely. If you recall, I did ask Detective Grossman, and he says that you do see some movement based on the shadows.
I recall that.
Based on, if you look, it's a double sync, and so you see two separate sets of shadows. And based on their positioning, he's able to project the location of the person where that shadow is. Where what we've provided and what Detective Ruano has subsequently slowed down in stills, and that's what we're going to be introducing to him, you can see it appears to be, and I know that in real time it's very difficult to see, but when you break it down, that black shape that you see flash in the lower right-hand corner, there appears to be a hand, or some sort of, it appears to be skin. He's going to opine what position that hand is in based on angling, just based on based on how the shadows are, what he sees. It's, in essence, there's no.
But let me ask you this. He's an accident reconstructionist, I understand.
Accidents.
But what gives him the expertise to be able to make such an opinion? If all he is doing is enlarging it,
Well,
or projecting it, as I believe the word you used, what gives him the expertise to be able to go further and make an opinion based upon shadows?
Well, Judge, I mean, in certain crime situations or in any kind of like real life application, these people that do these reconstructions can take any kind of tangible object or tangible representation, and then, I mean, if we have skid marks on the road, that gives you an indication of how a car travels, because it shows you the trajectory in which the tires met with the ground, and it leaves a physical response. Shadows are the same thing. They're a physical reflection of a human being. And so he's going to be able to say, I see two shadows, two separate sets of shadows. One has to be based on where the reflection of the sink is. He's gone to that sink. He sat there. He's scanned the entire room. They've deposed him on the equipment that he used. He'll be able to educate the jury and say, listen, I went in there with a machine. I sat there myself, and I looked at the sink, and I did what I needed to do in that kitchen to make a determination of where those shadows came from. I believe that's going to be his testimony, Judge. I haven't gotten, like, once again, this is Mr. Padilla's witness. Mr. Padilla has spent a ridiculous amount of time with Mr. Schumacher and Dr. Bodden. And so it's someone who's going to be like, I was there, I evaluated the scene, I made a determination not only based on my expertise, but actually physically being in that kitchen.
The state's on notice.
I was going to ask what
Mr. Yeager, are you ready?
we were going to do, but I guess regarding.
Well, I guess that, I guess.
I don't know where we finally decided, Judge.
I guess ultimately it's going to come down to when and if you all want to go take that deposition, if the defense is making a court reporter available to go to the hospital, and whether or not there's some indication that it's a safe environment
That I need to know.
for the parties to go to.
Well, once we determine whether it's a safe environment or not, we're going to need a specific time so we can at least start getting a court reporter ready.
So again, that just defers me back to the court's question about in terms of if Mr. Schumacher was going to be released tomorrow afternoon and we put him on, is the court inclined to then possibly inquire of the jurors if they would stay late and we go through closing so that they would have a little bit more than just the onus of getting this case Wednesday at lunchtime after closings and charging and all of that, or if it's the type of thing where if we ended late with Mr. Schumacher Tuesday, we were going to be resetting it for the following Tuesday, because then there's no rush, quite honestly, Judge, for us to go to the hospital. Otherwise, we would accommodate the court if the intention is to get it to the jurors tomorrow. That's all I'm trying to bottom line.
That's what I would like to do. Worst case scenario, Wednesday morning. But I would like to get it done before Thanksgiving. We've made that.
Judge, so would I.
We've made that commitment to these jurors. I think these jurors are phenomenal people because they have been so engaged with this process, and I think that if I can gauge their faces, their feelings, I think they're ready to
Judge, I'm not suggesting a delay. I wasn't trying to suggest it.
No, of course.
Right.
But I don't think that anybody in this case wants a delay. So
Why don't we agree on this? Let's agree on taking a deposition at 3 o'clock, so we can get a court reporter there. We'll get there a little bit earlier today, 2 o'clock, 2:30. Talk to the doctors, talk to the nurses, determine whether it's safe to walk in. But I need a time so I can get a court reporter. I can't just call a court reporter last minute.
So is it my understanding that after Detective Rwanda, the defense is done for the day?
Correct.
Judge, so then I would ask that we do what the court had suggested, which is, I mean, we can do the jury instructions, but that you take the opportunity to colloquy the defense, which
Right,
assuming
but obviously,
Mr. Zagany comes back in also.
if the defense puts on another witness tomorrow, he can always change his mind, but we'll take it moment to moment. Okay, so let's do this. Let's go through a first round of the jury instructions while we're waiting for Detective
Judge, do you have a copy?
Oh, yes, I do. I'm sorry. Deborah, can you pass these to the state? Okay, the first page is was what I read to the jurors during the Williams Rule testimony during the state's case. So you can disregard that. Okay, so page 1, introduction to jury instructions, final instructions. Any objection from the state?
No.
Defense?
No.
Page, phones off, folks. Page 3.2, statement of charge. Any objection from the state?
No.
Defense?
Judge, I believe the rules require that the court go over not only what's been charged, but the lesser included in each.
There's an instruction for that.
Okay, but I think under the statement of charge, in fact, the rule states in the comments, it says if there are multiple counts, the court should explain each count and the lesser included crimes related to it.
And I will throughout the package. So 3.2, any other objections?
No, Your Honor.
7.1, introduction to homicide. Okay, so let's talk about this.
Judge, I don't think murder in the third degree is a applicable lesser on these facts.
Defense, do you agree?
I agree.
Okay, so murder in the third degree will be taken out. And then I will take out the statute numbers for justifiable and excusable.
And murder in the third degree also appears the next paragraph.
No, it appears twice, yes. I'll take it out everywhere it is. Just give me one moment. Excuse me, I've been having some difficulties this morning with my computer, so just bear with me for a moment. Okay, so statute numbers removed. Anything else in introduction to homicide?
Nothing from the defense, Your Honor.
Okay, from the state? Okay, that will take us to 7.2, murder first degree. Again, I will take out statute numbers. State.
The transferred intent is not applicable.
Defense, do you agree?
Yeah, the portion that says transfer intent period, give if applicable period.
Yes, you
Yeah,
believe
take
it's
that
applicable.
out, absolutely.
You believe to take it out?
Yes, ma'am.
Okay.
And the following as well, not, another 2 paragraphs down, it says give only if there's evidence that the defendant acted in the heat of passion or legally adequate provocation.
That was to be taken out? Would folks still act like quiet in the courtroom, please? Any other proposed changes from the state or defense?
No, Your Honor.
No, so the paragraphs A, B, C, D, and E, those are all being taken out, correct? On adequate provocation or...
Is that, that's what the defense just requested,
Right.
correct?
No. What I said was this section here where it says give only if there's evidence, that one sentence should be removed.
Oh, they do want adequate, they want heat of
Oh,
passion.
you just want the instruction sentence. So you are requesting A, B, C, D, and E?
Yes.
Okay,
Okay, and state?
that's fine, Judge.
Okay. Look on the space in a moment. 10.13, shooting or throwing a deadly missile. The statute number will be taken out. Any other alterations requested from the state of Florida?
No, Your Honor.
Defense?
No, Your Honor.
16.6, neglect of a child. Any alterations requested from the state?
No.
Defense?
No, Your Honor.
Okay, that will take us to 3.4, when there are lesser included crimes or attempts.
Judge, I would just, I'm sorry, going back to the neglect of a child.
Okay, back to 16.6. Yes.
Definition, give if applicable. I think that sentence can just be deleted.
Okay.
Oh, yeah.
Okay. Thank you.
Detective Arano is present for the record.
Okay, well, we told our jurors they'll have another 10 minutes. Okay, 3.4, when there are lesser included crimes or attempts. The question becomes, is anyone requesting lessers?
Judge, the state is requesting lessers as to first-degree murder. We are requesting manslaughter and second degree. We are not requesting any other lessers as to the other crimes.
Defense.
We're requesting, we agree with the lessers on the first degree murder as to shooting or throwing a deadly missile. I think there are category 1 lessers.
Judge, I don't believe that discharging a firearm in public is factually...
Oh, correct. On the following one, there's on child neglect, there is culpable negligence, which we will request.
What is the defense's position on that?
There should be a sentence added.
One more.